All right. Hello, and welcome. I'm Otis Landerholm. I'm the founding attorney here at Landerholm Immigration, A.P.C, where we fight for your American dream. And thank you so much for being with me here today. And today I want to talk about cases for parents of United States citizens. All right. We've heard this term, quote unquote, anchor baby. All right. Somebody enters the United States, has a child in the United States, and now they think, oh man, now they're set, right? Now they can just, as soon as that child turns 21, all issues will be solved with immigration, right? Unfortunately, that's not the way it is. And the reality is there's a lot of misinformation out there. There's a lot of misinformation. There's a lot of misguiding. There's a lot of ignorance. And sometimes, unfortunately, there's a lot of misleading lawyers that say, hey, yeah, let's file that petition, collect a fee from it, but then can't do anything with it. And so what I'd like to do today is I'd like to really explain what options, what limited options are available if you have a child who's a U.S. citizen, all right? And so to do that, I'm going to share my screen and we'll get to it. So let's see here, share. All right, so I'm going to move my beautiful face here down to this corner. Nice. Okay, good enough. So options for parents of U.S. citizens. All right, and so here's the thing: you're only going to be eligible to adjust status in the U.S. if you can show three things. And this isn't just for U.S. citizens. This is the law to adjust status in the U.S., all right? You've got to show that you, one, were inspected and admitted or paroled. Two, that your child is a United States citizen and is 21 years old, all right? And now if you, this presentation is just for parents of U.S. citizens. So your child has to be a U.S. citizen. They have to be 21. If you're adjusting through a spouse, your spouse doesn't need to be 21. All right. So just for children to file petitions for their parents, they have to be 21 years old. And then the third requirement is you have to be admissible. All right, which I have lots of videos talking about admissibility. Basically, have you ever been arrested? Have you ever committed immigration fraud before? Have you ever lied saying you were a U.S. citizen? Have you ever helped somebody cross the border without permission? Have you ever done anything to like violate immigration laws before, have an unlawful presence bar, things like that? Talk to a lawyer to make sure that you're quote unquote admissible. If you're inadmissible, you might have to file for a waiver. If you are eligible for a waiver, great. If you're not eligible for a waiver, then that'll be a problem. All right. What I want to talk about in more depth is the first one, because so many of our clients come into our office looking for help, and they've got a U.S. citizen child here who's about to turn 21, but they were never inspected and admitted or paroled. All right. They crossed por el cerro, like they say, or they crossed over the hill, right, without crossing through like an immigration checkpoint. All right. And so just that first piece, were you inspected and admitted or paroled? Did you enter the country with a stamp in your visa, in your passport? Did you enter the country with a visa, with some kind of legal permit to allow you, the officer allowed you in? And so what does that even mean? There's a case, matter of Quilantan, if you want to know. There's a case that says that if you were sitting in the back of a car and the officer waved you in at the border, and you presented yourself in your car, and you were waved through, that is inspection and admission. As long as there was procedural regularity, that you weren't trying to evade immigration authorities, you presented yourself. If the officer let you in, then boom, you were inspected and admitted. That's awesome. So if you weren't inspected and admitted, there are some ways to get it. all right? One is there's a big exception in the law, which is for people who are protected under Section 245I of the Immigration Nationality Act, which if you've never heard of that rule before, you're probably not protected. But if you have heard of it, then be aware of what that means. What it means is somebody else, somebody in your family, all right, filed or it could have been an employer too, but typically it's a family petition. Somebody in your family filed a petition on your behalf on or before April 30th of the year 2000. All right, sorry, April 30th of 2001, all right? And you had to have been physically present in the United States on December 20th of the year 2000, all right? In 2001, April 30th, the old provision under 245I sunsetted. It went out of effect, all right? But for everybody that had family petitions filed on or before that date, they were protected by this law. And what this law allows people to do is it allows people to forget, it allows immigration to kind of forget or forgive the fact that they weren't inspected and admitted, as long as the person, the applicant, pays a penalty fee of $1,000, all right? And if they had that family petition and if they're otherwise eligible. And so if you're protected by 245I, brilliant. And yes, you will be able to adjust status through your child as long as you're still admissible, all right? The second thing that I really want to discuss is there are ways that you can get paroled into the United States even if you weren't inspected and admitted at the outset. So for example, if you have TPS, temporary protected status, and if we can get you a travel document to leave the United States and come back in, then that can be paroled. Now in the Ninth Circuit, I don't want to get too far into the weeds here. In the Ninth Circuit, there's a case that says that for Ninth Circuit purposes, at least, and until there's a decision contrary, right? Actually getting TPS is a form of admission. And so in the Ninth Circuit, at least, you have an argument to not even require this. But I'm just saying, there are ways to apply for what we call advanced parole for people who are in the US through TPS, also through DACA. If you are a DACA recipient, the latest memos, all right, from just recently here in 2020, allow a person with DACA to apply for advanced parole in an emergency situation. So if you have an emergency, family emergency to go visit, your loved one outside of the United States, you can use your DACA to apply for advanced parole, leave and come back in, and that will have you paroled in the United States and will allow you to adjust status through a U.S. citizen child, all right? The other one is what we call parole in place, and that is if you have a child who is in the U.S. Armed Forces, they can apply for a benefit that we call parole in place, all right? Which the Trump administration is wanting to discontinue, but it does exist, all right? And so if you have a child who is in the armed forces, talk to a lawyer and we can see if they can request parole for you. And then after paroled in, then you can, after becoming paroled in, then you can use that parole to adjust status, all right? The great thing about that is it's actually parole, they call it parole in place, meaning you don't have to leave and come back in. They'll just like give you a parole stamp while you're still here, all right? And you don't have to leave or go anywhere. So anyway, if you don't have the inspection and admission or parole, like if you entered without inspection, then you're not going to be eligible to adjust status, period, all right, unless you have one of these exceptions. And so there's a lot of misunderstanding about that, like, oh, I'm undocumented, and I was never inspected and admitted, but my child's about to turn 21, so as soon as they're 21, I'm set. It doesn't work that way, all right? And so you're only going to be eligible to adjust status, which means applying for a green card here in the US if you've got all of these three things. So if you're not eligible to adjust status, plan B is to consular process, to process your case outside the United States. But the problem is if you weren't inspected and admitted, you've accrued unlawful presence. And so the way unlawful presence law works is if you've accrued more than 180 days of unlawful presence, or even worse, if you've accrued more than 365 days of unlawful presence, and then if you leave, for example, to go to a consulate to process your green card, you're going to trigger a bar, all right? And if it's 365 days of unlawful presence, you're going to trigger the 10-year bar. And so so then you either have to wait 10 years, which I never want any of my clients to have to deal with, or we file a waiver. But the problem is you're only going to be eligible to consular process with a waiver if you've got a U.S. citizen or a green card holding spouse or parent, that's number one, who, two, would suffer extreme hardship if that waiver were denied. All right? And so now let's think about that. If you are undocumented and you have a U.S. citizen child petitioning for you, you probably don't have a U.S. citizen or a green card holding spouse. And I say that because your spouse would be petitioning for you. All right. Sometimes that might not be true, but you could theoretically have your child petition for you instead of your spouse. But if you have a U.S. citizen spouse or a U.S. citizen or a green card holder spouse, then typically that person will be filing the petition, all right? Now, if you do have a U.S. citizen or a green card holding spouse, you can argue and present evidence that that spouse would suffer extreme hardship, and then you can waive the unlawful presence bar, and then you can go consular process and come back in with a waiver. But it's just uncommon. So then the next question is, okay, if you don't have a U.S. citizen or a green card holding spouse, do you have a U.S. citizen or a green card holding parent? Where are your parents? You are the parent of a United States citizen, but where are your parents? Are your parents U.S. citizens? Are your parents green card holders? Or are your parents still in your home country? Because if your parents are still in your home country, then you're not going to be eligible for a waiver. And so don't do it. I mean, the only other, I should have put it on the slide, I suppose, the only other way to do it is to leave the United States, wait for 10 years, and then, yeah, your child can petition you with no problem because you won't be inadmissible anymore as long as the 10-year bar was the only issue. All right? So let me repeat that. If you're not eligible to adjust status, for example, because you were not inspected and admitted or paroled, then you're only going to be eligible to process through a consulate overseas if you have a U.S. citizen spouse or parent, or a green card holder spouse or parent, who would suffer extreme hardship. All right, and we can talk about what extreme hardship means. I've got videos about waiver cases if you do have a U.S. citizen or a green card holder spouse or parent. Now we've got to show that the level of harm that they would suffer if that waiver were denied isn't like the normal level of harm. It's not like a lot of harm. It's an extreme level of harm. It's like very high amounts of harm. Okay, so that's a waiver case. So then I want to just, explore other options as well. All right. If you're not eligible to adjust status here in the U.S., and if you're not eligible for consular processing, then might you be eligible for something else? And here's the truth, right? There are like millions of parents of U.S. citizens here in the U.S. who are undocumented, who are not eligible to adjust status and not eligible for consular processing because they don't have a U.S. citizen or a green card holding spouse or parent. you know, and so then the question is there one of these other options? So these other options, really briefly, and we've got lots of different videos on each of these, all right? And there are more theoretically, but these are the most common, all right? One, a U visa, all right? So the question there is, have you ever been the victim of a crime in the United States and reported it to the police? Well, if so, get a copy of that police report, take it into a lawyer and see if it's one of the qualifying crimes, and see, you know, and really go over each of the eligibility criteria to make sure you have a case for a U visa. The second option is asylum. And so the question there is, are you afraid for your life to return to your home country? You know, have you received threats, persecution, violence, serious bad things have happened to you in your home country, and you need protection for your life, all right? Life or freedom, I should say. And the problem with asylum is you've got to file within 1 year of your entry in the United States. There are exceptions if something serious has happened very recently, like you've received a recent death threat or something like that. But asylum is no small case, and they're not easy cases to win, and they're not fun cases to fight. And so if you are thinking of asylum, you want to lawyer up, and you're going to want to really talk it through with a lawyer who knows how to fight asylum cases and who's won them even under the Trump administration, because you know you want a lawyer who's willing to go to court with you and to fight the case all the way, because USCIS might very well, and the asylum office might very well deny the case, or not deny it, but refer it to immigration court. And then, you know, it's a very risky process, because if you lose, the judge will order your deportation. All right. So anyway, that's asylum. And similar as far as risks go is option number 3, which is cancellation of removal. The thing for cancellation is, if you have a U.S. citizen or a green card holding child, spouse, or parent who has a serious medical issue, all right, which is not written into the law, but basically, you know, our office will only help you file a case like this if you're not already in immigration court. We'll only help you file a case like this if you have, for example, a U.S. citizen child, young child, who has Down syndrome, who has autism, who has like a serious medical issue, all right? And if we can show that that child would suffer what the law calls an exceptional and extremely unusual hardship if you were deported. Sorry, I'll move this up so you can see the full language down here at the bottom. You know, if you can show that you have a U.S. citizen or a green card holding child, spouse, or parent who has a serious medical issue and who would suffer exceptional and extremely unusual hardship, which is like off the charts hardship, like basically, you know, they would really struggle to survive if you were deported, then and only then a judge is allowed to cancel your deportation in an immigration court proceeding. Now, proceed with caution here, because these cases, they're extremely risky, because if the judge approves your case, great, you can get a green card. But if the judge denies your case, they will order your deportation. All right. And so that's it. Those are the options that I wanted to present here today for parents of U.S. citizens. I'll just stop my screen share here. Thank you so much for watching this, and I really hope that this was helpful and useful. We will put our phone number here below this video, and if you have any additional questions, please don't hesitate. You know, reach out to our office. We've won all of these different types of cases and different types of options for our clients, and we have experience navigating this for people who are in that situation. And so, you know, if you are the parent of a United States citizen, you know, you are not alone. There are literally millions of immigrants who are undocumented immigrants who are hoping that they can fix their immigration status through their children. And the truth is that there are millions of children who are hoping that they can help out their parents. And it's like, okay, let's talk it through and let's think about it, and let's do a consultation, and let's figure out, hey, in your situation, what options do you have? How could your children help you out? Or if you're the child, how could you help your parents out? And yeah, let's talk it through and think about what our options are. And I hope this video was helpful. If it was, please give us a thumbs up or subscribe to our channel. I'm recording this, it's September 1st of 2020. And so, if you're seeing this, that's the date kind of relevance. We're in the middle of a global pandemic, coronavirus. And even in this, we are filing cases to help parents out. And we are helping people get informed about what their rights and what their options are. So thank you so much. And I hope you have a wonderful day. And I wish you the best of luck with your immigration case. Thanks again. I'm Otis Landerholm, Landerholm Immigration A.P.C, where we fight for your American dream. Take care. Bye-bye.